This video is about the UK Supreme Court and everybody's favourite topic, Brexit. Now this will look at the impact on the powers of the court that Brexit has had. We'll also look at how Brexit found its way into the UK Supreme Court in a couple of high profile cases. The first thing to say regarding Brexit in the Supreme Court is that, and I've laboured this in previous videos, the European Court and the European Convention of Human Rights still apply in this country post-Brexit. And there are a lot of people, both prior to and after the referendum, that believed that that would change if the UK voted for Brexit. But the European Convention of Human Rights was signed in 1950. And so the court is still in a relationship with and answerable to the European Court of Human Rights and can judge cases under the European Convention of Human Rights. The only way that the UK would change its relationship with the Court and Convention of Human Rights is if the Human Rights Act of 1998 was repealed. And remember, the Conservative Party do still have plans to repeal that act. And it has been in the Conservative manifesto since, I believe, 2015. It was certainly in the 2017 and 2019 manifestos. But until that happens, the United Kingdom will continue to have a relationship between its judiciary and the Court and Convention of Human Rights. But the two areas that are no longer applicable as of the 31st of December 2020 is the European Court of Justice. That is an EU institution. And the second thing underneath the European Court of Justice logo is Brexit involved sort of disapplying the Treaty of Rome to British politics. Now, the Treaty of Rome was signed in 1957, doesn't become applicable in the United Kingdom until 1973, when the UK joins what was at the time the European Economic Community. But essentially, what the Treaty of Rome said is that what is today's modern European Union takes precedence over the laws of individual nations. As of the 31st of December 2020, if you want to know the time, it was 11 p.m. As of that moment, the European Court of Justice and the Treaty of Rome were no longer applicable to the United Kingdom. And so, what does that mean for Britain and the UK Supreme Court? Well, there are three main changes. First of all, there's less caseload for the UK Supreme Court to take on, because there will no longer be challenges to the actions of the UK government or UK law based on the laws of the European Union. Secondly, because that no longer applies, the UK Supreme Court has lost that role of interpreting European Union law and whether it is applicable and in line with the law of the UK. So you could say that lack of caseload and losing that power to interpret European Union law means that the Supreme Court has lost one of its roles. However, you could actually turn that on its head and say that because the European Court of Justice is no longer superior to the UK Supreme Court, the role and significance of the Supreme Court has in fact increased, particularly concerning our human rights. So you could look at leaving the European Union in one of two ways. The Supreme Court has lost the ability to interpret the law based on what European Union law says, but it has gained more significance in the absence of the European Court of Justice. It is now supremely powerful. There is no other institution that can challenge its significance in the United Kingdom. And Professor Vernon Bogdanor, who you can see there, he is sort of the go-to thinker when it comes to the UK Constitution. You will see Vernon Bogdanor quoted or the author of many, many articles in Politics Review or in the British National Press. He is the go-to person for the British Constitution. He had this to say post-Brexit. Brexit will leave a gap in our Constitution in terms of the protection of human rights. This gap could well be filled by the judges. If that happens, Brexit will increase the danger of a clash between the judges and Parliament. So what he sees a possible future where the Supreme Court interprets the human rights of UK citizens, and it may lead to clashes between judges and Parliament, and it may increase the power of the Supreme Court. It may lead to claims that the UK Supreme Court has become politicised. We're going to look at two cases now. We've looked at the impact that Brexit has sort of had on the role of the Supreme Court. Now we're going to look at how Brexit ended up in the Supreme Court. And we're going to look at two cases, and they're essentially called Miller 1 and Miller 2. Now, Gina Miller is a business owner. She refers to herself as a transparency campaigner. She's the leader of the True and Fair political party. And in 2016, after the referendum, Gina Miller worked with a law firm in London to challenge the authority of the British government's decision to invoke Article 50 using the prerogative powers. Now, if you go back to Constitution, the prerogative powers used to be exercised by the monarch, are now largely exercised by the Prime Minister or the executive on the monarch's behalf. And the case brought forward by Miller, in the case Miller versus Secretary of State for leaving the EU in 2017, the idea was that only Parliament could take away the rights and laws that had been established by an Act of Parliament. The UK joined the European Union through statute law in the 1970s, and the case made by Miller and the law firm was that only Parliament could take it away. And the Supreme Court agreed with Miller's challenge to the British government's decision to act independently. The court agreed that it must be an Act of Parliament that must trigger Article 50 and begin the process of Brexit. So before negotiations had even begun, Brexit found itself in the UK Supreme Court over whose authority it was to begin the process of leaving the European Union. And the court agreed with the challenge that it is an issue for Parliament to deal with. So it was essentially re-establishing parliamentary sovereignty over the will of the government to use the referendum to trigger the Brexit process themselves. It's worth mentioning here that Gina Miller faced a huge amount of death threats, misogynistic abuse, racist abuse in the wake of that decision. In November of the year prior to the decision, a man was arrested on suspicion of racially aggravated malicious communications directed at Gina Miller. And there was an individual, Rodri Phillips, who was charged in March 2017 for, again, malicious communications. He was found guilty of those charges in July. In 2019, a GoFundMe campaign was set up and raised £10,000, which was purportedly planning to hire a hitman to kill Gina Miller. So this case came as a significant personal cost to Gina Miller, but it didn't dissuade her from bringing another case to the Supreme Court in 2019. Now, Gina Miller was one of many groups who brought forward a legal proceeding against the decision by Boris Johnson's government to prorogue Parliament. And the court agreed with Miller again. In a unanimous decision, they decided that Boris Johnson's advice to the Queen that proroguing Parliament was necessary, they agreed that that was unlawful. They essentially agreed with Miller that Boris Johnson had lied to the Queen. And actually, it wasn't Boris Johnson that did it. It was Jacob Rees-Mogg who was sent on behalf of the Prime Minister to tell the Queen at Balmoral that proroguing Parliament was necessary. So the court agreed in that case that that action was illegal. And in a similar case, being heard at the same time, the so-called Cherry case, that basically confirmed that the prorogation which had begun was declared null and void and had no effect, and that Parliament had never been lawfully prorogued and must immediately sit again. So MPs who were told that they were taking an extended break from Parliament were instructed to immediately return. So to summarise, post-Brexit, what are the three main roles of the Supreme Court in the United Kingdom? First one is judicial review, and they can review earlier legal precedent that has been set under common law or case law. Common law is essentially unwritten laws, and they are based on legal precedents that have been established in the UK courts over long periods of time. The second area is ultra vires rulings. The idea that the Supreme Court can decide when the executive or any public body has overstepped its powers. And again, we can use the example of the illegal prorogation of Parliament in 2019 as an example of that. And then finally, the last key role of the UK Supreme Court is that it can issue declarations of incompatibility between the actions of the government and British law with the Human Rights Act of 1998. And so one thing to remember is that though the court can declare incompatibility, and that requires action on behalf of Parliament and the executive, what it doesn't mean is that laws can be struck down, which happens in the United States. If laws are declared unconstitutional in the United States, that law is struck down. The UK Supreme Court doesn't have that power. So a declaration of incompatibility requires action, but doesn't have the power to strike down the existing law.